Good morning. Well, let's see here. Good morning, everybody. We've got a few folks still hung up in the waiting room, but I'm going to go ahead and get started with our Zoom housekeeping tips. We're happy to have you all with us here today. As a starting point, we generally ask everybody to stay muted unless you would like to unmute yourself to ask a question. It just minimizes background noise and makes it easier for everybody to hear the Q&A today. If you are wondering about where your mute button is, your Zoom toolbar is probably at the bottom of your screen, depending on what kind of device you're using. That's where you will find your mute and unmute button, as well as your start and stop video button. If you would like us to be able to see you today, feel free to keep your video on. If you would like privacy or you're working in the background, or your cats are crazy like my animals sometimes are, you can feel free to leave your video on for entertainment or turn it off as you prefer. This is also where you're going to find the chat button. For some of you, it might be flashing right now because I put a message into the chat. The chat is the best way to submit questions for us to answer today. We don't have a huge number of questions, so we might have time to answer some towards the end if you've got stuff to put into the chat. Like I said, you can also unmute to ask a question, and in that case, we'll ask you to wait to do that until we've run out of our, pre-submitted questions. The message that I put into the chat also directs you to our YouTube channel, which is where you can find all of the videos for previous Q&As dating back, almost 4 years now, which is kind of crazy. And also the message I put into the chat tells you how to submit questions in advance of next week's or each week's Q&A. So if we don't get to the question that you put into the chat today, we do try to keep track of them so we can put them on the list for next week. But you can also email them to info@condolaw.net so that they are added for sure to the list for next week. Every week we tell you the same thing, which is that we are not here to give legal advice. We're here to discuss general legal information. So number one, if you want to rely on something that we've said here as legal advice, you can't do that. Number two, if somebody sends you one of the videos and says, but condo law said, blah, 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 you can ignore them because this is not legal advice. This is just general information. If you have a scenario in which you need legal advice, you need to consult with your own association attorney. And the reason for that, beyond the fact that they have an attorney-client relationship with your community that we may not have, is that they also understand your specific governing statute, your governing documents, and all of the circumstances that you might be dealing with when you need that advice. And if you don't have an attorney and you don't need one right now, you should get one anyways. This is a great time to establish a relationship with a community association attorney. The best time to work on that relationship is when you don't need one, so that you're not scrambling in a moment of crisis. And if you are wondering about how to find an attorney that knows what the heck they're doing in this practice area, if you go to the WSCAI.org website and go to their directories, their member directories, business partner directory, I think maybe is what it's called, and search for lawyers or attorneys, that is going to give you a list of member lawyers and law firms who have expertise in this practice area, which is something I think is very important when you're choosing an attorney for your community. We also generally remind folks every week that the chat is, like I said before, for asking questions or requesting clarification on something that we've said, not for discussion or commentary like you might see on the CAI message boards. We haven't seen that kind of usage of the chat in a long time, so I don't even know how much we need to say that, but it's a decent reminder. We've been giving you the last few weeks a link for the proposed bill, which would make Wakaiowa applicable to all communities in Washington state. And I'm putting that link in again now. And also I want to let you know that it did pass out of the Senate, and it got probably twice as many yes votes as it received no votes. So I think unless something really weird happens, I think that this bill is very likely to pass. The effective date is not until January 1st of 2028 now. That's been bumped out. Initially, it was proposed that it would be effective January 1st, 2026. But in the negotiation process for the bill, that has now been pushed out by a couple more years. So it'll give associations plenty of time to work with industry professionals, their management company, their lawyer, to understand how the new law will impact each particular community. Because if you're governed by the HOA Act, the changes will be different than if you're currently governed by the old Condo Act or the new Condo Act. So just keep an eye on that. And another thing that I'm going to remind you about that we've been telling you about every week lately is the Monday morning minute emails from the Legislative Action Committee. If you have not signed up for those, please do. They're like 2, 3, 4 paragraphs once a week only on Mondays, and you get just a snapshot of what the most important issues are that we're working on each week. But every now and then there might be a call to action if we really want folks in the community to show up and sign in to either support or oppose a bill, depending on how the bill might affect community associations in Washington state. So please, please, please sign up for the Monday morning minutes if you haven't done that yet. And finally, we are not going to have a Q&A next week. So Wednesday, February 14th, which happens to be Valentine's Day, which is not why we're canceling the Zoom. We are not going to have a session, so we won't be here next week. Most of our attorneys are going to be traveling to the CAI National Law Seminar, which is in Vegas next week. So we're going to be operating on a skeleton crew in the law firm, and we are not going to do a Q&A next week. So please keep that in mind. Chelsea will be sending out an email next week on Monday that will tell you or remind you. Instead of a reminder for the Q&A, it'll be a reminder that we're not doing the Q&A, but we wanted to give you guys that information today as well. Jennifer, do you have anything you want to add before I jump into the questions?
No, I don't.
Okay. And again, I do want to remind folks, please stay muted unless you are unmuting yourself to ask a question so we can minimize background noise for the rest of the Q&A. Our first question is there anything in RCW 6434 or other applicable statutes that says that the majority of the board must reside on the premises? The short answer to this question is no. We did cover this question in more detail last week. So if you want to get some more details and more information on this question, go to the link in the message that I put into the chat, go to our YouTube channel and look at the video for last week's Q&A, which I just put up yesterday. So that was a little delay. I won't do that again, I don't think. But there is nothing in Washington state law that requires members of the board to be residents. If you want to add this requirement, you need to do it in your declaration or in your bylaws, wherever your documents currently cover qualifications for board membership. So if your declaration is where that's located, you need to amend your declaration. If your bylaws are where that's located, you need to amend your bylaws. I also want to point out the question asks about whether a board member has to reside in the community. That's different than whether a board member has to be an owner. And most documents require that at least a majority of board members be owners. So that is one thing to keep in mind. And again, you need to be really familiar with your documents to understand these requirements. We do have clients that have a really interesting variety of requirements for board members. So we have some clients with multiple buildings within their community that will require one board member from each, or one owner, excuse me, from each building to be allowed to serve on the board at the same time. We do have communities that allow or require all board members to be owners. We have other communities that have long-standing board members who are not owners, but who are residents within the community. So each community balances what their interests are and what their desires are in terms of deciding the qualifications for board membership. And then you have to amend the appropriate document in order to make that enforceable within your community. I do think it's worth pointing out, one of the things you want to balance is, yeah, it would be nice if more of your board members were people who lived in the community or who were owners. But on the other hand, it's often very difficult to get people to volunteer to be on the board. And so the more requirements you place on board members, the harder you make it for folks to serve on the board. And it used to be pretty difficult for a non-resident person to serve on the board because board meetings had to happen in person. Now that all of the governing statutes have been changed to provide for virtual meetings, folks who don't live in the community can attend board meetings much more easily. And so that's, one less impediment to service on the board. And so again, you're balancing all these different considerations and desires as you make your decisions about these qualifications. But going back to the question itself, there is no statute that limits board membership to those who reside within the community. Jen, did you have anything to add to that one?
I don't. So moving on to the next question. This is regarding annual budgets. If anything on the annual budget allocations presented to the owners for a vote is incorrect, must the budget be I'm sorry, I haven't had enough caffeine yet. Must the budget be resubmitted for owner vote? Example, an income item is listed as an expense item. Note, this would not affect the dues amount. So this question is actually a little too specific for us to give a general answer on, but we'll try to give as much of a general answer as we can. In general, the budget is the association's best guess as to what'll be needed for meeting the association's obligations in the following year. If there's a mistake in the calculation, as long as that mistake does not affect the amount due per unit, the board has discretion to allocate money as it sees fit. And one case that we found is KCV Sudden Valley. This case basically stated that the board can change spending from the budget if the revenue is not adequate. So what this means is the dues or assessments are a lump amount. The board can change how those amounts are allocated according to the from what's on the budget if it's necessary. But if the error is substantial or has the potential to be controversial, the easiest way to fix this and prevent an owner challenge, a possible successful challenge, is to just re-ratify the budget. Ratifying the budget is extremely easy. You don't have to have quorum, and it erases all of these problems. Valerie, did you have anything to add?
I don't. Well, that's not true. I do. The only thing that I want to add is one of the things that really helped me understand the fluidity of a budget is exactly what Jennifer said, that it's a spending plan. It's not set in stone. So just like a household budget, you think you're going to spend X number of dollars per month on something, but then, I don't know, you have to replace your tires unexpectedly. You have to shift money around in order to meet that financial obligation. And in the same way, an association, a board, and their manager can put together the best, most detailed, effective budget possible. And then things happen throughout the year to change how that money needs to be spent sometimes. And that change is okay. I do have a question about the math in this question, because the question says, and the example is that an income item is listed as an expense item, but then the question says it doesn't change the dues amount. And if an income item is, counted as an expense item and that's a mistake, then fixing it would change the amount of the dues or the total amount of the budget for the year. So I was a little bit confused by that comment in the question, but I think Jennifer's answer is still correct, regardless of whether the question is, as we think that it is. All right, next question. If a board member's term expires and there is not a quorum at an annual meeting, and those whose terms have expired decide they will continue on the board, what actions can owners take if those directors choose to ignore the declaration? Examples: would the owners file a lawsuit? Would a property management company have a legal responsibility to confirm votes of the board to ensure declaration compliance? Would we revise the state records to show those officers were not on the board? So, it's very funny, not funny. We go through these questions pretty extensively. Usually one of us will review the questions, type out our answers, and then one or two more of us will look at it and add our thoughts. And it's only upon this particular reading of the question that it occurs to me how many layers really exist here, okay? Because there's a few different questions that are brought up by this paragraph. One is, what happens when a board member's term expires and there isn't quorum at a meeting to elect new board members, right? And the short answer to that question is a board member serves even after their term expires until their replacement is elected or appointed. The fact that their term has expired and that a replacement has not been elected does not invalidate their service as a director. It does not invalidate their ability to govern the association as a director on the board for that particular community. So while it is true that in order to conduct business at your annual meeting, including a board election, you have to have a quorum, and that can be counted by whoever is there in person or by proxy. You achieve that quorum either of those ways. The lack of a quorum and the inability to hold an election does not mean that everybody whose term is officially expired is somehow like magically not on the board anymore. So you serve until your replacement is elected and confirmed to the board. So some of the other questions that are brought up by this question to me include things like, how do you handle it when you can't get quorum? What if people want to leave the board and there are other people who want to volunteer, but you can't hold an election because you can't get quorum? Well, the answer to that question is the current board members have the authority to appoint replacement board members whenever there's a vacancy. And there is case law in Washington state that does confirm the validity and the authority of a board that has either just continued to serve term after term and or that has appointed replacement board members to fill vacant spots on the board, even in the absence of an election. I think the case that Ken was talking about when we were chatting this morning was they hadn't had an election in something like 8 years. But the court affirmed the authority and the validity of the current board that had been appointed over those years because the association, the board followed correct procedure in appointing replacement folks to serve when positions were vacated. The other layer that's in this question is what actions can owners take if the directors choose to ignore the declaration? It's really hard to comment too much about this without understanding what the person meant by this question. What I mean by that is, did the person think that just by their continuing to serve on the board past the point where their term expired, that was a violation of the declaration? Or is it that you as an owner think your board is just doing a bad job and they're ignoring the governing documents in the decisions that they make for the community? And I'm going to go with an answer to the latter, since I think I already covered the former by talking about the validity and the authority of a board that continues, past the term expiration. And I would definitely not jump straight to an owner suing the association because you think the board is not following the governing documents. There are a lot of steps that can be taken short of that if you think that your board is not handling things correctly. One thing that I would suggest and encourage is that you attend board meetings if they're open, pay attention to the minutes when they're provided to the ownership, or request an opportunity to review them if your community doesn't automatically send them out to all of the owners. Volunteer to serve on the board. As I've mentioned before, and we've talked about many times in this Q&A, it's often a really big challenge to get enough people to serve on the board in a lot of our communities. And one of the things that we suggest the most frequently when we run into owners who are vocally and vehemently critical of their board is put your money where your mouth is, serve on the board, or volunteer to serve on the board, serve on a committee that works with the board, find ways to be involved in the community. If you really think that there are serious violations happening, you can consult with an attorney that might help you put together a letter, for example, to your board, pointing out what you think the issues are and asking them to come into compliance. You could also ask your board to participate in a mediation with you so that you can work with a third party, an impartial third party that sort of can help you guys, discuss the issues that you see within the community and perhaps come to an understanding that would help, number one, avoid litigation, which is expensive and alienating and a very adversarial process. But number two, you have to stay in that community unless you sell your property, right? Beyond the time when the conflict is resolved or the issue is resolved. And so mediation is a process, especially if you use a mediator that's familiar with community associations. And WSCAI has a fantastic, really cost-effective mediation program that would fit the bill for this. those types of mediators understand the ongoing nature of the relationship. Once the dispute is resolved, it's not like the parties never have to see each other again, which is often the case in other types of disputes or litigation situations. But you're going to continue to live in that community for as long as you own your home. And so you want to preserve that relationship as much as possible. Management company obligations are defined by the management contract between the management company and the association. In general, I think a reminder that is useful is that the management company acts as an agent of the association at the direction of the board. So the manager does not have any oversight over the board. The manager doesn't get to tell the board what to do. The manager doesn't get to pass judgment on whether the board is doing things correctly or not. Certainly, many managers, in particular those who have a lot of experience within this area, will have opinions and sort of personal evaluations of how they think the board is handling things. But there's no mechanism by which a manager can enforce their opinion of a board's actions on the board itself. So your options are really to volunteer, to try to elicit additional interest and volunteerism within other people in your community, to communicate with your board whenever possible, try to suggest a mediation if that seems like it might be useful. And litigation is an option, but I think it's worth pointing out again that it is expensive, it's time consuming, and it can often lead to worsening of relationships within the community as opposed to bettering those relationships. So that was a lot. Jennifer, do you have anything you want to add to that one?
Just briefly, both the nonprofit corporation statute, the new act in Ukiah, and the HOA Act have provisions where the owners can come together, call a special meeting, and recall board members or the entire board. So another way for you to work on this situation is see if there are other members in your community that have the same opinion you do, and see if there's enough interest to recall the board. I will say that we've had situations where board recalls have been attempted that were not successful. I think in the 7 years I've been doing this, maybe one successful recall, something like that. It's very rare, but it can happen. So you have options besides litigation. And as Valerie said, litigation is extremely expensive and extremely alienating for the rest of the community. So trying some other steps before going straight to litigation would probably be your better bet. So next question. We have a problem with people moving out and dumping stuff, usually in the middle of the night and always around the end of the month. I've heard of associations that charging a move-in fee that is non-refundable to help defer the cost of this. Any other solutions? So typically move-in, move-out fees, rental administration fees can only be assessed if the authority is in the declaration. That being said, if there are specific costs tied to association expenses, those may be able to be shifted to the owner of the unit, but it really depends on the language in your documents. You can also fine owners for rules violations and assess costs for dumping to that owner if you're able to figure out who did the dumping. And honestly, one way to find out is to install surveillance cameras around the trash receptacle area and see if you can catch people doing that. Valerie, did you have anything to add? Oh, you're muted.
Rookie mistake. I do not have anything to add. I will go ahead and move us on to the next question, which is, can board members vote at meetings by absentee? Our board plans to vote on a contract at its next regular monthly board meeting, which is conducted via Zoom. We normally prepare the motion in advance of the meeting. Could board members who cannot connect for technical reasons or who are out of the country and can't attend live due to time zone differences provide an email or written message in advance that states their vote, yes or no, on an issue? So the short answer to this question is no. if you're conducting the board vote at a board meeting, you cannot do that by way of a proxy or absentee ballot at that board meeting. So the statutes you want to look at, one of them is in Wakaiowa, which again, remember, eventually is probably going to apply to all communities in Washington state. And that is RCW 6490-445, subsection 1M, like Mary. It prohibits board members from voting by proxy. The Nonprofit Corporations Act also does specifically prohibit board members from voting by proxy. And the section of the Nonprofit Corporations Act that we're talking about here is RCW 2403A 565. And that section also requires that board members be present, that's the word used in the statute, for the purposes of both establishing quorum and voting. So not only do all these statutes prohibit the scenario that's described here, but it's also contrary to Robert's Rules of Order, which again is not binding on all of our communities, but is instructive for sure. And it's also very likely that absentee voting or voting by proxy would violate the board's statutory duty of care to the association. State law and case law very heavily favor board decisions that are made at real-time board meetings, which require the ability in real time for board members to hear and communicate with one another. The idea is that when you're in a room together, or you're all on a Zoom together, or even on a conference call together, you can not just hear what other people are saying, but you can speak yourself. You guys can ask questions, you can argue with each other, you can actively discuss and engage in that duty of inquiry that you have as board members to suss out the issues that you're voting on, right? So it's okay to prepare, for example, the text of a motion ahead of time, just because maybe it feels a little bit less stressful than finding the right words to say in the moment, right? But you can't go into the board member treating that decision as a foregone conclusion, and you can't hold the board meeting without quorum, and you can't allow board members who are not there at the meeting to vote as though they were. The only other way to make a valid board decision in Washington state, and this is only true for non-Wakaiowa communities, is to make the decision unanimously and in writing. So an email would be a writing, or you could do like a board resolution in lieu of a meeting. And in that case, again, the decision has to be unanimous, meaning every single board member has to vote, and they have to vote the same way, and it has to be in writing. If you were to make the decision unanimously in writing outside of a board meeting, we strongly recommend that at your next board meeting, you ratify that decision and record the action in the minutes of that board meeting. You might also attach the unanimous writing to the board meeting minutes as evidence of the fact that the board voted unanimously and in writing outside of the board meeting to make that decision. But again, that you want to be careful with that. In particular, if you're a Wakaiowa community, Wakaiowa specifically limits the types of decisions board members can make outside of a meeting to ministerial decisions only. So if you're voting on a contract, that is a substantive decision. That's not a ministerial decision. And that is a decision that Wakaiowa communities have to make at an open board meeting. The other thing that, you know, I'm going to sound like a broken record, I think, for the rest of this legislative session until that bill passes. But the writing is on the wall here, folks. If Wakaiowa is going to apply to all of us, that means that even if you're in a community that currently does allow unanimous decisions outside of a board meeting, that may not be true for very long for the rest of our communities who are eventually going to be subject to Wakaiowa. So we have long beat the drum for all the 4 years we've been doing this, and for many years before in different forums, that the gold standard for enforceable board decisions is for them to be made at board meetings. And I think eventually the law is going to require that for all of our communities because of this Wakaiowa for All bill that's coming down the pike. Jen, did you have anything you wanted to add to that?
I don't. So the next question. Pros and cons of having a social media page. What should board members comment or contribute on? So there's no legal answer to this question. Statutes and case law don't speak about social media pages for community associations. You may want to talk with other boards in communities near you, or your management company or other managers, to hear pros and cons and avoid pitfalls that others have experienced. Couple thoughts and just general advice. We do not recommend individual board members respond or comment on social media, because board members outside of board meetings are owners just like everyone else. Unless they have authority to speak for the association granted in a board meeting, they cannot speak for the association. What they say is their own general opinion, but other owners are likely to treat that particular individual as a board member, even outside of board meetings. So you really need to be careful there on who is speaking and doing what. And then, honestly, it would be better to have owners submit questions or comments, and the board can address them at a board meeting with the responses, and then have those published. That way everyone is getting the same information at the same time. The board has time to investigate, review the question, and make sure that they all agree on the answer. And then some thoughts that Ken had, and that were actually pretty interesting. So ask yourself, what is the purpose of the association social media page? Is it to promote sales and the value of the property, inform the residents of activities, or provide records for review by owners? So some of these questions may help answer this, because you can get most of this information on a static web page. If you are looking at social media for a small community, like Valerie earlier brought up, Facebook groups, that works as well, but it may not be the best forum for your community. So it really depends on what you're looking for. Most management companies will set up a website or some sort of web portal with financials and governing documents for association members to view, but that doesn't count as social media. Valerie, did you have anything to add to that?
I don't. Nothing to add. Thank you, Jennifer. Our next question is this. Because of the number of revisits by our fire and safety company for fire alarm inspections, the suggestion was brought forward to have a locksmith on site during our annual fire alarm inspection. We plan to provide our residents many months advance notice with various options for the required unit access. We want to explore the option of having a locksmith as part of our inspection team to open units that are not readily accessible, and then bill the unit owner for the locksmith's time. What kind of language do we need to have in our declarations to allow this, and or what kind of language do we need to include in our notifications to allow this to happen legally? So I think, that question is very clearly asking for legal advice. So I need to start by saying, I can't answer that question for your community because it depends on your specific governing documents, and I don't have that information available to me right now. So in order for you, the person who submitted this question, to get an answer to the questions that you asked, you need to send this to your association attorney so they can look at your governing documents and tell you what your options are. It might require a declaration amendment to allow you to pass these types of costs back to an owner. I also think that, you have to be careful about entering units without owner permission. And there's a lot of different scenarios that I can think about that might play out in this kind of scenario. So one, you send out the notice of the intent to enter the units for this fire safety inspection. And one scenario is that you just don't get any response at all. So the day comes, you knock on the door, there's no answer, nobody's responded. Perhaps the risk of entering in that scenario is relatively low. What we want to be really careful about is safety is like the number one thing that we think about in these situations. And so if there's somebody in a unit and you enter without their permission, we don't want our managers and your vendors to be unsafe. I know it's rare, but it's certainly not unheard of that managers have been shot or otherwise harmed when entering units in community associations. And so that sort of awareness of that risk and safety is like the number one thing that we think about when we're evaluating scenarios like this with our clients. The other possible scenario is you send out the notice of intent to enter and an owner responds and says, absolutely not, I am not giving you access to my unit. In that scenario, we would almost always tell a client to get a court order before breaking into the unit, because that's essentially what you would be doing, is breaking into the unit, right? Generally, if an owner has affirmatively refused access, unless there is a real-time emergency like a fire or a burst pipe or something like that requires immediate action because it's actually an emergency right now, we will tell our clients that you need to go get a court order instead of entering the unit against the owner's wishes in a non-emergency situation. But again, I think a failure to respond is different than an owner who says, no, you can't come into my unit, right? And also the history of how these things have played out in your community probably makes a difference. The types of relationships you have with the owners in your communities probably makes a difference. We do have clients that assess the cost of return trips for these safety inspections to the owners that failed to give access when adequate notice of the need for access was given to the ownership. But again, you have to verify the authority for that in your governing documents. You have to document that in the warning or the notices that you send to the owner. Some documents will require that you give an owner due process before you assess any of these types of costs to the unit. So that's all really specific, not something we can cover in the context of a Zoom. And this particular question, you need to send to your association attorney to get an answer that is correct for your community. Jennifer, did you have anything you want to add to that?
Just to reiterate, I get this question fairly often. How do we enter a unit where the owner is either unavailable or is refusing access for whatever reason? And your community attorney will have the best answer and be able to guide you through the steps. This is not something that you can just do on your own with general legal information. So next.
May I ask a question?
Of course.
To this direct question, I get the assumption that the association wants to have current keys available to get into units in the case of an emergency. So is that the background for this question? And are we talking about a condominium? Or are we talking about a lot owners association made up of single family homes?
So
we can't answer that.
So
we don't know.
Right, we
the
don't
only
know.
information we have is what was given to you. So this is a very case-by-case association-specific question, and so is the answer. So that's why we recommend speaking with your association attorney before you attempt to enter units.
I do think it's safe to say a couple of things. I've never heard of a single family home lot community where the association is doing fire safety inspections in the single family, like freestanding homes. So it is almost certainly safe to assume, but again, it's an assumption, that this is a multifamily building that's a condominium, townhouse, something like that. And as far as the keys go, we have some communities that do request, and which in their governing documents, it says that the board has the authority to require the owner to provide a current key for access in case of emergencies. But there are also plenty of documents, in fact, more of them, that don't say that, where the association is relying on the owner to provide a method of accessing the unit. And then it's up to the owner, right? Am I okay with giving the board member or a manager a key? Am I going to take the day off work to be there to let them in? Do I put a keypad on my door, right? Like the practicalities of that, we just can't comment on. But I would not assume that this scenario requires an owner to turn over a key. That is, although sometimes in the documents, relatively rare.
And honestly, if it is in your documents, we recommend our clients don't do that just because of the liability factor if something happened that and some unauthorized person gained access to the keys. Yeah. Moving on to the next question. If the association has raised their insurance deductible and are requiring owners to have their individual policies updated to cover these funds, is this something that needs to be amended in their declaration or CC&Rs? Can this be covered in the rules and regs? So this really depends on the language in your governing documents. If your governing documents do not have language that allows the association to shift responsibility for uninsured loss or the cost within the association's deductible, you cannot assess that cost to owners. There is no requirement under any of the current statutes, including Ukiah, for owners to have insurance. So unless your documents have been amended to have this language, you cannot shift responsibility for the association's deductible to individual owners. So another issue that we've come across over time is in the 90s, several association attorneys in our practice area were amending the governing documents to include a specific deductible amount. Typically, the language is 1% of the face value or $10,000, whichever is less. If your governing documents if your declaration has that language, your association is limited to having a $10,000 deductible. It's in your declaration. That is what you're required to do, but your insurance company might not be offering that to you. So what happens in that particular situation is that you're only allowed to assess the $10,000 deductible. Anything above that $10,000 is a common expense. So this is really, really language specific for what's in your governing documents. And honestly, please do not put a specific deductible amount in your declaration. Deductibles will change over time. Currently, well, back in the 90s, $10,000 was a lot of money for a loss. Now it's fairly routine to have a $10,000 loss. So having that language in your declaration limits the association on what they can assess. And with deductibles changing over time, every time you have to change your deductible, because that's what's given by your insurance company, you're going to have to go back to your owners and ask to amend the governing documents, which right now is, I think it's $1,300, $1,500 for us for a declaration amendment, plus recording fees, which are now $303.50 for the first page. So you're looking at a ridiculous cost to amend your governing documents to keep up with changes in your insurance policy, when honestly, the authority just needs to be in the declaration, but the dollar amount can be set by the board and by what's given by your insurance company. So the declaration should specify that the owners are responsible to have coverage at least in the amount of the association's deductible. Every year when the insurance policy is up for renewal, the board can send a letter to the owners with notice of the deductible amount. We don't recommend having a specific deductible amount in the declaration or rules. Having that written down binds the association and honestly gives a cost for having to change it. So lots of communities are choosing to increase the deductible due to insurance costs, and then others are given no choice by their insurance companies due to loss history or other factors. The good news is it's much cheaper on a cost per dollar of coverage basis for an individual owner to insure themselves up to the amount of the higher deductible, the association's higher insurance deductible, than it is for the association to keep a lower deductible. But again, this language has to be specifically in your declaration to be able to shift these costs to the owners. If it's not there, you don't have that authority. Valerie, did you have anything to add?
Nope, I think you covered it. Our next question is this. We are a small 5-unit building governed by the old act. Any experience invoking 6434-360 from the new act for an old act condo if the governing documents do not specifically adopt that provision or any new portion of the new act? And the particular provision that's called out by this question talks about the assessment of common expenses. And the short answer is that certain provisions of the new Condo Act apply automatically to old act condos, no matter what's in your declaration. Other provisions of the new act apply to old act condos only to the extent that it's not inconsistent with what's in your declaration. And then other parts of the new act just don't apply at all. And this particular section can only apply to an old act condominium to the extent that it is allowed by your declaration. So if you have language in your declaration that is inconsistent with this provision of the new act, then your declaration overrides this provision of the new act. So the short answer to this question is, I don't know if your particular community can rely on this section of the new act, and nobody can answer that question without reviewing your governing documents. So you might want to submit this question to your association attorney to get the answer. Jen, did you want to add anything to that?
Just briefly, if your declaration does not specifically allow certain costs to be shifted to owners, so you want to use the language in 6434-360, unless that language is specifically in your declaration, the answer is probably not, because it's unless the declaration provides. So if your declaration does not provide, it means you don't have that authority. Moving on to the next question. So we are a small 5-unit building governed by the old act. 2 of the units are currently being rented, approximately 40% of the total. We are concerned about being re-rated as an apartment building if our master insurance carrier learns of our percentage of rentals, which might increase our premium by as much as $25,000 a year, solely on the basis of number of rentals. Any experience with the board allocating such a premium to the owners of the 2 rental units as an assessment under the annual budget, as opposed to a vote of all the owners? So there's no authority to shift costs of insurance or increase in insurance to individual owners. In the old act. In the new act, that language may be there, but only applies if it's allowed by your declaration. So this honestly is not something that we've heard of before. The idea that insurance companies won't insure if there are more than 50% rentals, and that's where we typically hear where that number is. We don't know that it's actually a standard by many association insurance companies. So one question that honestly I'm a little curious about is, are you using an insurance company that's familiar with community associations? If you're not, go on to the WSCAI website, and under resources, there's a business directory. You can find insurance companies there that are familiar with community associations, and they may be able to answer these questions for you a little better. Aside, if you want to limit rentals, you can always amend your governing documents to include a rental cap. Because you're an old act condo, the percentage of rentals, or excuse me, the percentage required to amend your governing documents is the same for a rental cap, is the same as it would be for any other amendment. So you can also adopt Ukiwa, which allows a cap of 50% by rule, which is based on current banking industry standards. So some documents allow the association to allocate insurance costs based on risk. This is a very specific analysis, and it requires analysis by your community association attorney who can view your documents and knows your situation. So just in general, you probably can't do this, but speak with your association attorney. Valerie, did you have anything to add?
Nope, I'm going to move on to the next question, which is from the same person. So small 5-unit building, old act condo. The question is, do you have any experience with allocating a $5,000 deductible for claims under the master policy on a per unit basis instead of by ownership percentages for each unit? And the answer to this question is no. As a general rule, common expenses, of which insurance premiums and deductibles are a part, are allocated based on percentages, not divided on a per unit basis. This is assuming there isn't something specific in your documents that would authorize this, and that would require your attorney to look at the documents to give you an answer to the question. So these last 3 questions were all submitted by the same person. And I think the short answer to all of these is this is not the correct forum to get specific answers to these questions. We've covered the topics generally, but if you want an actual answer for your community and your documents, you need to consult with your association attorney.
One thing I would like to add as well is that if you want to change your governing documents to allow any of this, speak with your association attorney, then they can help you with that. So moving on to the next question, we would like to know if a condo association receives a letter from the next door neighbor's attorney, does the association have to hire an attorney to return a response, or can they answer this themselves? It really depends on what is being asked or demanded. So typically for our clients, we recommend sending any legal correspondence that you get over to us. It doesn't mean that we state blanketly, oh no, we have to respond. It's just, what are they asking? If they're just asking for the association to trim trees or enter into some sort of an agreement to fix a fence, something of that nature, then no, you don't necessarily need an attorney to respond. But if they're stating you must do X or we're going to sue, that's something that should probably be reviewed by your association attorney. One thing that we came up with, and Valerie's smiling, she knows where I'm going with this. Honestly, just because you can doesn't mean you should. So have your association attorney take a look at it and they will give you the best advice. Valerie, did you have anything to add?
No, I think that's exactly, I mean, yes, I guess I do. Yes, I have something to add. The idea is there are more than 2 options. The question sort of presents it that either we respond or either the attorney responds. And those are the only 2 options. And the third option is you at least have your attorney glance at it and give you their thoughts on whether this is something you guys can handle on your own or whether it's something that requires attorney involvement. And that kind of quick analysis, I mean, shouldn't take more than, I don't know, unless it's a really long letter or super complicated issues, maybe a half an hour, maybe less. So the thing here is you don't want to be penny wise and pound foolish, right? Don't work really hard to save yourself the few $100s that it might take to have your attorney look at something or even draft a quick response at the risk of potentially costing your association thousands of dollars down the road, depending on what the issue is. All right, I'm going to combine our last 2 questions, Jen, since they are both on the Corporate Transparency Act and we are coming close to the end of our time here today. Maybe that way we'll be able to get to a couple of the questions from the chat. So we had one request just to sort of cover the topic of the Corporate Transparency Reporting Act generally, and then another one which says, I've been looking at the information on the Corporate Transparency Act, which appears to require that all HOAs report all the owners, including private information that no owner I know of is required to provide to the HOA. I understand that CAI is lobbying to postpone implementation, and I'm wondering if this topic has been addressed in a previous video or will be addressed. I also wonder if our bank will facilitate having associations collect the information and submit it to the government, or are we just supposed to know about it because of outreach, not done by formal notification, and whether this is a strategy for non-compliance. So I want to say, first of all, we're not here to talk about and give you strategies for non-compliance. That just kind of like set my lawyer bells ringing. So I just wanted to say that first out loud. I also wanted to point out that we did cover the Corporate Transparency Act sort of as a preliminary topic on our January 17th Q&A, and the requirements were covered in that video. So please check the video out on our YouTube channel for that. I also want to say that the information required is for board members or beneficial owners. And a beneficial owner is typically someone who exercises control over at least 25% of the ownership interest in the community. So this is not a statute that's going to require you to report the information requested for every owner. Only board members and any owners who own more than 25% of the ownership in the community. Banks are not required to help file and would not know the information requested, so I'm not really sure where that part of the question comes in. And there is she asked a question about whether there's a financial threshold, for example, if the budget is less than $10,000. The exemptions are for entities that employ more than 20 people and file tax returns showing more than $5 million in gross receipts. So the exemptions are actually kind of in the opposite direction, as the question might suggest. I want to say just generally that the Act does require answering questions. It is generating a lot of confusion and a lot of concern. There is an effort in Congress right now to delay implementation or the filing deadline. So right now the deadline is January 1st of 2025. So we've got 11 months almost before this deadline comes. That being said, if your community is concerned about this, certainly the lowest risk option for any community is just to comply with the reporting requirements now or before January 1st. Alternatively, you could wait to see if the efforts to delay the implementation or the filing date will be successful, or see if the efforts on CAI's part to exempt HOAs are successful. A recent CAI publication suggested that 501c4 entities might be exempt from the reporting requirements. So that's one thing that you could look into. Or you can wait for a definitive evaluation of whether you get an exemption because you are a nonprofit and no single person in your community controls more than 25% of the ownership. So there is time if you want to postpone compliance, but if you want the lowest risk option, just do it now or start putting plans in place to handle it now. Do remember that you're required to update the information every time there is a change. So anytime you have a change in board membership, you're required to update the information that's required by the Corporate Transparency Act. So Jen, do you have anything you want to add on that, or should I jump into the questions from the chat?
Just briefly, and honestly, I think a lot of the confusion regarding this particular statute is that it's meant to combat and bring light on money laundering in small nonprofit or small corporations. So HOAs or community associations are kind of being lumped into this, not on purpose. We think it's an unintended consequence. But honestly, as Valerie said, the easiest, least risk heavy way to deal with this is to just comply. We're kind of taking it may be good to take a wait and see approach, at least until maybe early summer or late spring, and then start making a push. So you're making sure that you get the information to FinCEN before the deadline.
There's a follow-up question on this in the chat. And it says, do you suggest we start notifying our board members now, or should management companies wait to see what happens until towards the end of the year? And I think there's two answers to this question, because there's sort of two pieces to this decision-making process. If the question is, should management companies be telling boards that this might be coming down the pike? My answer is yes. If the question is, do we need to tell our boards they have to start complying now? My answer to that question is that each board has a different level of risk aversion and can make that decision for themselves as to whether to start the compliance process now or whether to wait until closer to the end of the year to comply and hope that one of these exemptions or delays actually comes through. We had a different question. Oh, go ahead, Jen, sorry.
Oh, just briefly, and honestly, most annual meetings happen at the end of the year anyway. So your report now may be different than what it is in October, November.
Yeah.
So just informing owners that this is coming and this may be required of new board members, honestly, may limit the number of individuals willing to serve on the board, but it's your safest option.
I think we have one question in the chat that is easy enough to answer that we can squeak it in before 11. And it is this: are there provisions in the Nonprofit Corporation Act which allow board members to appoint officers like treasurer, VP, etc., in addition to having a fully elected board? And I'll take a real quick stab at this and then Jen can fill it in for me. Yes, I cannot tell you the provisions of the statutes right off the top of my head, but the general rule is the ownership elects board members or directors generally, and then the board within itself appoints directors to particular officer positions like president, vice president, treasurer, secretary, etc. Did you have anything you want to add to that, Jen?
We have communities that are confused by what is a board officer or what is an officer and what is a board member. And some communities will have an elected board and then have another election for officers, which is honestly really confusing and adds a layer that doesn't need to be there. So Valerie is correct. The owners elect the board typically from among, unless your documents say otherwise, the board chooses officers from among the board members.
That brings us right up to 11 o'clock. So thank you again for being with us. Don't forget, we're not here next week. So we'll see you guys in 2 weeks.